Now let's talk about ADR and risk management, especially in an evolving business environment. And we have a super panel for you in the pipeline. Moderating this session is going to be Joza Rashid, managing partner Herbert Smith Freehills. And on the panel is going to be Dr. Abdullah Al-Ghamdi, the Vice President and Associate General Counsel at Saudi Aramco, Dr. Sanjeev Gemawat, Group GC at SR, Gao Huandong, Vice President and Deputy General Counsel at the Lenovo Group and General Counsel at Lenovo China, Catherine Karakatsanis, President VIDIC, and Diane Weiss, Global General Counsel at PwC. Wow, what a lineup. Please give them a warm round of applause.
Thank you for joining us today. I'm Joza Al-Rashid, Managing Partner of Herbert Smith. I have the honor of moderating this distinguished panel. In today's session, we'll be tackling the topic, Alternative Dispute Resolution and Risk Management. Both are essential tools to settle disputes efficiently and mitigate potential losses. ADR encompasses various non-litigious tools, including negotiation, mediation, and arbitration, while risk management is all about identifying, assessing, and mitigating potential risks. Our discussion today explores the intersection between ADR and risk management and will be addressed by our panelists that come from various sectors, mainly the energy sector, technology, consultancy, and engineering. Each will provide their unique personal perspective on tackling ADR and risk management, bearing in mind these are their personal views which may not reflect their esteemed organization's views. Now, I would start with Dr. Abdullah because we're going to go through each energy, and as previously introduced, Dr. Abdullah Al-Ghamdi, he is the General Counsel and Vice President and Associate General Counsel of Saudi Aramco, and he oversees Aramco's dispute portfolio both globally and locally, including ADR. Dr. Abdullah, in your views, Aramco as a global leading company, with the status and continued success, it only makes sense that Aramco managed to devise a robust strategy to mitigate risks associated with disputes. We would like to have a better understanding of the measures that have been taken or the methods which Aramco is following.
Thank you, Joza. Assalamu alaikum. It's a very interesting question because disputes and conflicts are the cost of doing business, as initially highlighted Dr. Nabil's Mansour speech earlier this morning. As a key player in the commercial arena, we do acknowledge commercial disputes. But what might distinguish us a bit different or position us different than others is our approach towards addressing risks associated or stemming from those commercial disputes. Given the large scale and complexity of our operations, we always aim at resolving conflicts prior to them evolving into adversarial proceedings. As we all can appreciate, not all misalignments or disagreement need to result in adversity. This is especially the case when there is alignment at the commercial level between the parties. We do take that into consideration whenever we structure and develop our dispute resolution clauses in our various agreements. Now, when it comes to risks associated with ADR, conceptually those can be categorized into two buckets. The first are risks associated with the business, so risk imposed on the business as a result of potential disputes. And the other category are risks associated with the actual proceedings or the legal proceedings of the disputes. When it comes to business risk, one must carefully consider the potential implication a potential dispute might have on the business. Such risks may materialize into disturbances and deliveries or execution delays, or even reputational damage. Now, obviously, each one of those has a real value attributed to it. The way we mitigate against those risks in our commercial agreements is to ensure that they're structured in a way with an aim to ensure business continuity. And this is done, obviously, as I mentioned earlier, that not all misalignments or disagreements need to result in adversity. We aim to resolve them before they materialize. So we do that through enshrining and hardwiring an internal claims process in our contracts, which allows parties to amicably and business to business discuss those discrepancies or misunderstanding with the supervision of a technical committee that will aim to reach an amicable conclusion to the dispute. All of that while the performance under the contract is being done and the business continuity is guaranteed. Now, on the other type of risks, those are the risks associated with the legal proceedings. We aim to address those through, again, careful crafting of our dispute resolution clauses by ensuring that the elements of the arbitration clause are carefully selected. And those elements obviously include governing law, the venue, the forum, and the type of the adjudication. Obviously, we do acknowledge in a company as big as Saudi Aramco that the contracts are different, and what might work for a procurement agreement might not necessarily work for a cross-border transactions or in an M&A transaction. So in order to balance the risk mitigation of those various elements in the dispute clause and enabling our business to proceed with their negotiations into those transactions, we equip our transactional lawyers, those who are actually negotiating the deals, with what I call a menu of pre-approved elements. So this menu would include pre-approved choices of governing law, forum, venues, institutional arrangements, whether it's the SCCA or other entities that the parties might want to agree. And the benefit of this is that the lawyers who are negotiating those transactions, they're comfortable that whatever they choose from within this menu has already been vetted, the risk has been mitigated, and we as dispute lawyers are comfortable with whatever they select and choose from this menu.
Thank you. So following on that, from your perspective and position in an institution like Aramco, what do you see as the key challenges in ADR, and how do your organization navigate these challenges to ensure fair, commercially viable, and efficient dispute resolution?
Thank you, Josa. I mean, ADR is an essential tool for resolving disputes, especially in a commercial setting, particularly for companies who are engaged in large-scale, complex, and high-value contracts. It offers flexibility, confidentiality, and in some cases, a more cost-efficient and expedient resolution process. However, while ADR presents significant advantages, it does come with its own challenges. Some of those challenges are key and must be addressed to ensure that ADR, specifically arbitration, remains an effective and a reliable dispute resolution mechanism. A key element of those challenges are the adjudicators themselves, or the arbitrators who are adjudicating the dispute. In litigation, the inherent risk of adjudicators is somehow cured through the litigation process. You would have an appeal process, and obviously you would have a judicial supervisory bodies who oversees the judiciary. In arbitration, it's a bit different. While finality in arbitration is something attractive, it's often difficult to find those qualified arbitrators, not only qualified in law, but also qualified in the complex technical matters of the dispute, who would comfortably reach that finality. This issue was particularly magnified with ad hoc arbitration. Prior to the establishment of reputable institutions here in the region, it was a bit difficult to identify those qualified arbitrators. Frankly, even with institutions and the fact that institutions are using rosters to identify arbitrators within certain categories, it's still a bit challenging for us as a client or as a customer to those institutions to identify arbitrators with niche, skilled expertise in specific matters of the disputes. As we can appreciate, disputes are gonna be more complex, are going to be more technical, and would demand a niche skill set that would enable the arbitrators to navigate the ship and land into an acceptable resolution. I'm cognizant of the time, but I would like to note that Such matters could be mitigated, coupled with the institutional processes that the various institutions do offer, such as the SCCA. We do take into account the qualifications of the arbitrators. So in our arbitration clauses, in addition to identifying the typical or the quintessential elements of the arbitration clauses, those are the governing laws and the other elements, we do somehow require certain expertise or experiences in our arbitration clauses when it comes to selection of arbitrators. Those include specific expertise when it comes to technical matters, expertise with certain governing laws, even language expertise depending on the language of the contract itself, in addition to other bespoke requirements depending on the technical nature of the agreement itself.
Thank you very much. That's very
Thank you.
Cool. And now we move over to Dr. Sanjeev Gimawat, who currently serves as the Managing Director and Group General Counsel at ISAR Group. For all of you, ISAR is one of India's largest multinational conglomerates operating across energy, infrastructure, metal and mining, and technology, among other sectors. Dr. Sanjeev has nearly 3 decades of legal experience and is widely respected in the legal field, and he has been named in very prestigious lists, including Forbes India, to name a few. Thank you for joining us. In your experience as Group General Counsel of a diversified multi-jurisdictional business group, what, in your view, are the various legal and regulatory risks which business deal with, and what risks assessment and mitigation strategies need to be followed by the group?
Thank you, Zoza. Thanks, SCCA, for inviting me to share my views here. Well, Zoza, in an organization, the groups which are operating in multiple geographies, multiple jurisdictions with diversified businesses, risks are manifold, because we have different jurisdictions, different cultures, different way of interpretation of contracts. But then if I broadly divide my major risk, I think largely they are anything which is leading to my business disruption, that is a risk. Anything which leads to any financial obligations, that is a risk. Anything which leads to my reputational damage, that is a risk. Now, these 3 risks basically arise out of the way in which, or the areas, or the location, or jurisdictions in which we operate, and of course, the industry, of course, the nature of contract. And if I want to divide these, these risk areas, it appears to me that broadly any legal and regulatory compliance mechanism which is required in a particular jurisdiction, and if I fail to do that, it leads to a risk. If I am not having a contract or the commercial understanding structured properly and in a contract, provided in a contract, there is a risk. And of course, the litigation and arbitration, as Abdullah also mentioned about the litigation and arbitration and the structured approach in terms of having those particular clauses. Now, let me give you some examples here, and which will give you the perspective how this happens. Environmental issues are the major issues in all jurisdictions. In one pretext or the other, even the procedural non-compliance on environmental issues that may lead to disruption of your business. The contract gets breached. And why the contract gets breached? Because at times, the understanding about the contract, the inferences or the interpretation of the contract might be different. People read it differently because people are coming from a different, diverse background. At times, besides the contractual interpretation, there are commercial volatility in the market. And the market volatility leads to parties breaching contracts. Parties, or ultimately all these are commercial organizations. And commercial organizations do weigh their pros and cons in terms of breaching the contract. And breaches happen because of that. Breaches also happen because parties at times have emotional issues. I will teach you a lesson. Now, that teaching you a lesson leads to disputes. Litigations gets enhanced because of teaching you a lesson. Now, in this backdrop, we need to see that how these risks evolve and how you address those risks. I was, listening the unsettled Mr. Takadi before this conference. And he mentioned in his presentation that there are 93 countries where unsettled model law is adopted. And he mentioned, I think, 126 jurisdictions where the model law is there. Despite the model law there in these multiple jurisdictions, the law is not the same. Abdullah mentioned about his structured approach in terms of providing in a contract the governing law or the law leading to the seat of the arbitration. And of course, you will be putting all these safeguards in terms of the governing law is important, the seat of the arbitration is important, enforceability of a contract or enforceability of award is important. Despite of acceptance of the model law, the local practices are different. Take example of liquidated damages. Under English law, the way in which the liquidated damages would be treated is not the same in many other common law jurisdictions. The same liquidated damages can be treated as penalty. Practices are different. And if you're operating in civil law countries or common law systems where the common law system is adopted, the way in which you are reading a contract is very different when a lawyer from a civil law jurisdiction would be reading it. You might have structured the contract in terms of your understanding, but the risk which lies ahead is how the other parties, how the other system is interpreting the contract. So I think the way in which I look at it is risks are manifold, multiple geographies, multiple jurisdictions, and all these things may lead to your business disruption, your reputational damage, and your financial obligations. Now, what is important is that somewhere we need to identify, assess, and mitigate this risk. It's not impossible, as Abdullah also mentioned. It's not impossible. You need to somewhere mitigate your risk in terms of structuring the contract, and it cannot be the fit for all kind of situation. Depending upon the jurisdictions, you will have to change that. Harmonization of contract or the consistency of contract is important because one organization, for example, if I talk about the energy sector, you cannot have the multiple contract of one particular industry in various jurisdictions. You will have to ultimately follow the same kind of contract. Or so is the case that if you are having a diverse businesses in one particular jurisdiction, you as an organization, you cannot have different sets of agreements. Somewhere you need to have harmonization and consistency. But despite that, somewhere we need to be taking into consideration those kinds of elements which may lead to disputes and which may lead to obligation or the higher level of risk in terms of disruptions and reputation and so on. And for that, what I would suggest is that, yes, once you identify, assess and the risk, then you will have to structure your contract, your compliance mechanism accordingly. And I think that a structured approach in terms of the compliance system, a structured approach in terms of the contract execution and contract drafting, perhaps might help in terms of addressing this. Yeah.
Thank you, Dr. Sanjeev. I think to wrap up, to combine both Aramco and SR energy powerhouses have the same approach in terms of risk mitigation. I think, Dr. Sanjeev, you stressed about the interpretation of contracts, which I would like to further address down the road with Ms. Catherine when I get to you about the interpretation and contract drafting. But now I would like to move to Mr. Huandong Gao, who is the Vice President, Deputy General Counsel of Lenovo Group. So we're moving away from the energy and now we're touching across the technology sector. Dr. Gao is in charge of the Legal and Compliance Department, including ESG at Lenovo, but not only that, he is an arbitrator of Beijing Arbitrator Commission, Beijing International Arbitration, Shenzhen Court of International Arbitration. So thank you for joining us. Dr. Gao, given the fast-changing geopolitical landscape and complex US and China relationship, as the General Counsel of Lenovo China, what is the risk that you see as the biggest risk from a legal and compliance perspective?
Thank you, Java. It's a great pleasure and honor to be here and attend this panel with our distinguished guests. When we're talking about the risks, we are talking about the strategic risks for the company here. From my perspective, Lenovo as a technology company, we are definitely have our special situations in these fast-changing and complex geopolitical situations. I put it as 4 categories of different types of risks. I think number 1 is the risks caused by geopolitical situation and the tension between China and the United States. And this well relates to different type of risks. One is we believe it's international trade compliance related, covering trade compliance and economic sanctions, and also very clearly targeted on semiconductor industry and AI industry. So this is something that if we don't manage this kind of compliance risk from a regulatory perspective, it will bring disaster to the company in the global operation. And I think the second type of risk caused by also the geopolitical situation is the so-called data sovereignty and the data security issue. Most of you know, in today's world, the data cross-border transfer has been caused the concern from many countries. I still remember one interesting example. One time, the United States government requesting companies from China to provide convincing evidence proving that we don't use the raw material and the labor forces from New Frontier province or Uyghur province. And on the other hand, the Chinese government requests that any important information related to global supply chain should not be provided cross-border. So this is a typical example of the conflict of law between China and the United States. So as the legal professionals and the compliance guy, how you manage this type of obvious conflict of laws issues to help your company deal with that. So this is kind of geopolitical cost risks has now becoming our day job for legal and the compliance team. And I think the second type of risks is industry specific. For our high-tech companies, I think IP-related risks, especially the so-called ACEP, standard essential patent disputes, have become the one of the top priority risks for companies like Lenovo. So in this particular area, we have many disputes with different companies like, you know, probably I cannot name the names of the company, but in this area, for ACP risks, we have to use maybe all kinds of dispute resolution mechanisms, including court or arbitration or mediation, or sometimes it's a combination of 3 of them. And I think the last category of risks we also are dealing with now is because of China as a national strategy, many Chinese companies go invest outbound. Saudi Arabia is a typical and very hard topic and very attractive, destiny for many Chinese companies. So for a company like Lenovo and other companies like Huawei or ZTE, we have to also conduct the country-specific due diligence to understand the culture, the history, the social value, and the legal framework in that particular country. In that way, we can avoid many risks from beforehand. I would just stop here for, in terms of the mapping, the histories, or do the risk assessment for the company like Lenovo. Thank you.
Thank you. And I commend you, Lenovo, for investing in Saudi a quite sizable amount and for taking these considerations before. I think it's a very useful and efficient way to avoid any, I would like to ask you a second follow-up question. I've heard that there is a recent trend of mediation as one of the ADR mechanisms in China. So can you tell us a bit or shine upon the developments on mediation and how is it being tackled in China?
Yeah. Mediation has been increasingly becoming more and more important in Chinese companies to deal with the different types of risks. Traditionally, Chinese people will, on the company, go to the court and also maybe choose arbitration. But now, in maybe the last 5 years, we see the trend very clear. Mediation has becoming more and more popular and chosen by different clients and companies. Why? It's very simple. Because the market economy has developed in China and the size of the economy has increasing, and more cases and disputes are coming out. The court in China has too, overloaded with cases, and also the cost issue is another consideration. Probably another consideration is the culture background. Traditionally, the countries in East Asia prefer mediation and friendly settlement versus arbitration or court litigation. And it's another interesting point I want to make is that we notice that in China now, many companies choose mediation, and because of mediation, some colleagues think it lacks enforcement capability, or normally it's non-binding. So many clients and Chinese companies now, they tend to negotiate and settle and sign a mediation settlement agreement, and then they will, beforehand, they will choose another arbitration organization to formalize this settlement agreement and enable it has legal enforcement capability. So that's the kind of maybe a creative solution for dispute resolution. Thank you.
So much. That's very helpful. And now we move on to Ms. Catherine Karakatsinassis. Ms. Catherine is an award-winning structural engineer and is the president of the International Federation of Consulting Engineers, known as FIDEC, and also is the president of the Canadian Academy of Engineering and a board member of the Canadian Council of Academics. She has received various awards, and namely, she was named Canada's Top 100 Most Powerful Women Hall, among others. So very honored to be here with you. And I wanted to kind of ask you, given your dual roles, the unique kind of roles, being the president of FIDEC and being at the forefront of the Council of Engineering, could you please share with us what are the strides that both institutions has done to navigate the disputes and to mitigate such risks, if any?
Thank you. I want to first start out by saying what a pleasure and honor it is to be here. It's my first time, and I'm really impressed, and I want to congratulate the event organizers for a very impressive conference. As you said, I'm a structural engineer, and I've worked in the consulting engineering industry for 30 years. Started out as a structural engineer. I've done project management, construction management, litigation, testimony, and ended up being the chief operating officer of a multidisciplinary consulting engineering firm. So I sort of live day in and day out with the challenge of delivering projects successfully and navigating the risks associated with them. In addition, as you said, I'm also chair of the board of FIDIC, which is the International Federation of Consulting Engineers. We represent the consulting engineering industry around the world. That includes about 100 countries, including Saudi Arabia. We met with the Saudi Council of Engineers yesterday. And that, really represents 1.5 million engineers around the world. So FIDIC, the International Federation, is known for its contracts. We do a lot more than that, we advocate. But our contracts really take arbitration and dispute avoidance very seriously for a lot of good reasons, and some of them have been mentioned today and discussed today. Really, obviously, dispute avoidance is very critical in ensuring that we deliver successful projects. As a consulting engineer, though, I first try and address the risks by training the engineers, the project managers, our management team, in really analyzing the contracts that we're entering into. And so we do training about acceptable clauses, non-acceptable clauses. We escalate the review if an engineer or manager is coming across clauses that are not typical or acceptable, we'll escalate the review, we'll get legal review, management review, and we'll often turn down work if we find the risk of the contractual clauses are unacceptable. The other thing we do is we train our team on how to keep clean files. So to make sure that they document the appropriate things, that they realize that their email messages, their text messages are now all discoverable. I recently had a very lengthy, many multi-million-dollar arbitration, and 7 years of emails, files, minutes of meetings, texts of hundreds of participants didn't lead to one instance where we had misspoken or misstepped. And part of that was because we also, once we realized that the atmosphere was not as amicable and collaborative as we liked, we brought in our lawyers to help us navigate through all the risks that arose. We also make sure that we do have the resources to deliver the scope of work. In the schedule, we make sure we have the fee that we can deliver the work and the contingency. And we choose our partners appropriately. We also have senior project sponsors on projects that meet with the team regularly to evaluate the risks or meet with our clients. But from the FIDIC contract world now, really our contracts are used worldwide. They're very highly regarded because they're fair. They allocate risk appropriately, and they've been developed with input from all the stakeholders. So we're finding that they're being used around the world more, increasingly. They're an accepted form of contract and standard use in bidding documents for multi-development banks, including the World Development Bank, the Asia Infrastructure Investment Bank, the African Development Bank, the Inter-American Development Bank. We all have multi-year agreements with those banks to use FIDICs. The drafting really is to identify issues early and deal with them early. And what we're promoting is a dispute avoidance board that can help with that. And so you prevent the escalation that could really turn into major disputes. And by resolving them in a timely way, you achieve so many things. You really retain the environment of a collegial and collaborative relationship with your partners, which leads to more business eventually and a better reputation for you. You avoid the costly expense of delays in a protracted claims, the delay claims, the expense of the claims itself. You really are able to have a successful project in a timely way if you can identify them early. So really, I guess in conclusion, you know, we have produced a procurement guideline that can help the team contracts really look for opportunities on how, when to address disputes early. Thank you.
So lastly, but surely not leastly, Ms. Diana Weiss, she is the Global Counsel for PwC Network. And PwC doesn't need any introduction, I think everybody knows. And she leads an international teams of professionals who support the PwC network with expertise in various sectors: ethics, compliance, regulatory, litigation, amongst others. And prior to joining PwC in 2012, Diana was a partner at the esteemed law firm King & Spalding, and she had a leading practice that is mixed between litigation and regulatory, and she represented a wide range of clients. We're very happy to have you here, and I just wanted to kind of pick your brain. As a professional service firm such as PwC, how do you think about ADR in the context of managing risks? You've heard the other panelists. I just want to see how you compare and contrast between them. Thank you.
Yes, thank you. Is this working? Because there's no
It's
light
working.
on. Yeah, great,
Yeah.
great. My first question back. So I just first want to say thank you. The presence of the SCCA says a lot about Saudi and what you're trying to do commercially. Developing a reliable and stable and accepted means to resolve disputes where they occur, and promoting mediation, as I understand you are, is obviously critical to attracting capital and having businesses feel like they can safely take risks and do work where you are. So very happy to be here. So as mentioned, PwC is ubiquitous, essentially. We are in 156 countries, and one of the risks that we have to manage that is most important to our brand is association risk. Essentially, our brand becomes associated very quickly with anyone who we do business with. We are the auditors for some companies on this stage, and we do significant consulting work and other types of work for probably many of the businesses in this room. And I'm quite certain that you count on our reputation certainly not making yours worse. At the same time, when we think about how to manage risk, we have to think about, first and foremost, are the people that we're doing business with the kind of people who we think we can resolve problems with when they arise. And that starts hopefully way earlier than having an actual dispute. So I would just echo the sentiments from all the industries represented on the panel about clarity of roles, understanding responsibilities, understanding where you're doing business, and investing time in who you're doing business with as the best way to manage risk. You know, a dispute, a real dispute with a client is a failure before you have even set out to figure out how to resolve it, right? Second thing I would say about our profession uniquely is that we cannot plan for contractually for the resolution of many of the disputes that we end up with because of our client portfolio. If a client of ours has a significant problem, say loses a sizable amount of its market cap, and we're its auditor, we will be exposed to potential claims from parties who we don't do business with. That doesn't mean that ADR doesn't play a very important role in how we think about those risks as well. And what I would say is that there are places in the world where having the entire arsenal of ADR available to you is critical to being able to manage very, very sizable risks. We are sometimes sued in existentially large cases that we're able to take privately, agree with investor groups, and get all the right stakeholders at the table and resolve confidentially in ways that are somewhat beneficial to everyone, or they wouldn't settle. But that is only because we're able to have, without prejudice, confidential settlement conversations, and that's not true everywhere. And in this region in particular, that is a challenging thing, right? And so knowing where you're doing business and what you can rely on in terms of how you can resolve a dispute is very important. I would say local knowledge is critical, but also knowing what's important to you as a brand is also critical. We frequently are told by lawyers representing our firm in all parts of the world, well, you have a fantastic case, you should take this to trial. It would be weak and indicate wrongdoing for you to try to resolve this in any other way. And we often say, thank you very much, but we're much more interested in protecting our reputation, resolving this issue with our client and moving on, and accepting responsibility where we have it, right? And then learning the lessons from that and bringing them back. So I think it's critical to have a foundation in the values that your organization thinks are most important as you approach dispute resolution, sort of no matter where you are. But it certainly multiplies the complexity when you're in places where you don't have the full arsenal at your disposal.
Thank you. And I think that from different sectors, but you all kind of agreed on one point, is that local kind of expertise, knowing the local laws and customizing your approach is imperative for to successfully dispute or settle the dispute. And also having a systematic approach, I think, because once you're a big organization, you cannot afford to have different templates here and there. So it's a systematic approach where you ring fence the risk. And that's something that is interesting that all of you, I think, agreed upon in different ways. Now I would like to kind of ask you, how do you think about managing risks as a global network that might be different than a corporation, in particular when operating across different jurisdictions and legal systems? So what do you see as the difference between that?
Yeah, maybe not so relevant to everybody, but I think it really goes back to the point about having a brand, because we are locally managed, which is a very valuable thing, you know, to our clients in every place we are, but we also have to try to have a consistent set of values and brand that we manage to, and how we try to avoid disputes is different. So I think I sort of covered that earlier. I might just say that, you know, it is a less command and control environment to manage risk in, when you're trying to set standards for everyone, you know, who has the brand to follow all around the world. And
thank you for that. Just to follow up, Dr. Sanjeev mentioned something very interesting about, he stressed about interpretation being taken off-piece, different depending where you are. Have you experienced the same in your role in terms of the contract being misinterpreted by the local courts or, you know, where you operate?
Yes, absolutely. And if you just take the United States as an example, we have had the very same arbitration clause calling for certain types of selection of private arbitrators, et cetera, interpreted completely differently in different states, and respected or not respected. And then we don't use the same arbitration provisions all around the world, of course. We try to tailor them to the local jurisdiction as appropriate, but absolutely have had situations where in liquidation, for example, which is a critical time to have an arbitration provision enforced, because you're dealing with a party who is not necessarily commercially motivated on the other side of the case. We can have them respected in one jurisdiction, ignored in other jurisdictions, interpreted very differently, all the same words.
So I'm going to circle back to Ms. Catherine. Just in terms of contract drafting, what are the kind of keynotes or advice you would give anybody? Because you mentioned discovery, and this is something that resonates well with my disputes team, that you need to prepare ahead of time, have, you know, proper filing of everything throughout the project, because if a dispute happens, proper filing kind of streamlines the whole kind of fishing through hundreds of emails and try to prove that you said this and that. So what are other things that you think that the audience would kind of benefit from your experience?
Me?
I think, as I mentioned, training is important. oversight by senior management, help when you need it from lawyers. But FIDIC, if you do get in on a project though and have a dispute avoidance board, that's also very helpful on a very complex project, because the guideline that we produced actually helps them to create a collaborative environment so that you can bring up the issues easily. And the document really also gives some advice as when, how to do it, how to bring it up, how to deal with it. So you can do as much as you can to avoid in preparation, like I mentioned, with the staff. But once you're on the project, issues do come up. And then, you know, having a tiered approach, which FIDIC contracts also have, so you start, you know, to deal with it at the project level. If that doesn't work, the next tier, the next, until hopefully you avoid arbitration, because it is very costly. It's distracting. Like when staff are preparing to defend themselves, they're not working on the project. It's very stressful, very distracting. I've had engineers and architects who have come crying. You know, they work so hard to do the best they can, maybe give up weekends and nights, and then they're having to sit there and defend the great work they've done. It's very stressful. So it's good to, if you are in a very complex project, consider a dispute avoidance board to help you navigate them.
Thank you very much, and a special thanks for my fellow panelists. It was very engaging, and it was an honor moderating you, really. Thank you. That's a wrap up. Thanks.
Thank you.